District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Doug Wallace presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning. Welcome to this session of the Second District Court of Appeal. We have three cases on the oral argument calendar this morning. We'll take them in the order in which they appear on the docket. We allow 20 minutes to the side for oral argument, although you're not required to use all of that time. And if you're the appellant and you wish to save any time for rebuttal, I'll allow you to save up to 5 minutes, and you'll tell me how much time you want to save when you start. I'll try and keep track of that for you. The first case is Hazel Peters versus Bank of New York Mellon. Mr. Stopa?
Good morning, Your Honor. Mark Stopa, counsel for the appellant. Latasha Scott is with me at counsel table. You'll notice her co-counseling in some of these cases with me. I would request...
Let me take up just a housekeeping matter before we get started. Your notice of appeal was filed on behalf of Hazel Peters and Dave Peters, and the brief indicates that, seems to indicate you just are representing Hazel Peters. So can you tell us who you represent?
We're prosecuting the appeal on behalf of Hazel Peters, Your Honor.
And you don't represent Dave Peters?
Not prosecuting the appeal on his behalf.
All right. Well,
I think the result is the same either way. I don't think it changes the analysis.
Can you file something with the clerk's office just to clarify who you represent for us, please?
Sure thing. I apologize for any...
All right. Thank you.
Yeah, error there.
All right.
So I would request 5 minutes for rebuttal.
All right.
Your Honors, there's a statute of limitations for everything except murder, and there was no murder here. So the first issue before the court is how to apply the statute of limitations on the plaintiff's lost note claim on the facts at bar. Now, this is an issue of first impression not only in Florida but in the United States, as far as my research can tell. But the statute of limitations analysis in any context is like this. The statute of limitations begins to run when the cause of action accrues. The cause of action accrues when all elements of that cause of action occur. Here, it's undisputed, and the record reflects that the bank sued to reestablish a lost note in both 2001 and again in 2004. In addition, there was a lost note affidavit. The lost note affidavit upon which they rely was dated October of 2006. Yet the bank didn't file this lawsuit until January of 2013, more than 6 years after the lost note affidavit and many, many years after it had initially filed suit to reestablish the lost notes. Now, I think that there's a fairly debatable argument whether or not the statute of limitations for a lost note claim falls within the ambit of 95.112B, the portion that allows one to sue based on written instruments, which would then be 5 years, or whether it better falls within the catch-all provision of 95.113P, which is 4 years. But either way, it's clear that the statute of limitations barred the plaintiff's claim to reestablish the lost note. My opponent's arguments otherwise are predicated upon what the trial court concluded by saying, well, as a practical matter, a lender would only have a need to reestablish the lost note if there's a default, and the default that they sued upon was in 2008, so it was hence brought in a timely fashion. Your Honors, a default is not an element to reestablish a lost note. The note being in default is not an element to reestablish, so hence that has no bearing on when the statute of limitations begins running. It has no bearing on when that cause of action accrued. So that argument, respectfully, there's no case law to support that, and that's simply not a correct legal position. My opponent also talks about the windfall nature of this, how this could result in a free house. A few comments on that. First, this is a very infrequent fact pattern. This doesn't come up very often. Okay, so this isn't like Bartram or like free houses across the board for everybody. This is a rare fact pattern. But more important than that is that that really has no bearing in the analysis here. That's not a legal reason in which to rule in the bank's favor. As an example, I cite the Lord case from the 4th DCA, where that court, in a similar context, talked about how its ruling under the then existing version of the lost note statute may result in a windfall to the borrower, but it didn't matter, and they did it anyway. Because if the lost note elements couldn't be established, they ruled in favor of the borrower as a matter of law. And what they did in writing that decision, which I thought was pretty interesting, was suggested that the lost note statute be amended to cover the specific situation at bar there, and that's actually what happened thereafter. The legislature amended the statute. Now, it might be that your honors may think that a default should be an element of a claim to reestablish a lost note. It might be that you might think that the legislature should draft 95.11 or 673.3091 in such a way that a cause of action to reestablish a lost note is predicated upon a default, or that a default is an element of the claim. But respectfully, that's not your decision to make. You don't get to legislate that issue from the bench. So I submit that one appropriate result on this fact pattern is to reverse, to say that the statute of limitations did bar the enforcement of the lost note claim. And if you want to suggest that the legislature investigate or revisit that issue on this specific fact pattern, I think it's within your purview to do so. But I don't think it's within your purview to do what the bank requests, which is to simply ask that your honors ignore well-established law about how the statute of limitations applies. You look to the cause of action as it accrued, the elements that occurred, and it's very clear that this cause of action accrued back in 2001, and certainly in October of 2006 when the lost note affidavit was executed. Now, I note that the Florida Supreme Court decision in Bartram doesn't change any of this at all, because the issue in that case was that when a lender can sue for foreclosure when there are changing default dates. Every monthly payment creates a different payment obligation, and so the statute of limitations, even if it's barred on one monthly installment, it's not barred on future ones as long as the suit is brought within 5 years. That's a totally different analysis here, because there the cause of action is different, because every monthly payment is a different obligation, it's a different cause of action. Here, in a lost note claim, the lost note claim in 2001 is exactly the same as it was in 2013. All the elements accrued. There's nothing that's different about it in 2001 versus when the suit was brought, nothing different about it in October of 2006, the lost note affidavit time versus when the suit was brought. So reversal is clearly appropriate on that first basis, as well as a decision via a written decision that reflects the statute of limitations applies in a lost note case. I noted it was a bit of a light example about there's no murder here, but it's true. There's a statute of limitations for everything in the civil context. There has to be one here, and the only way to enforce it in a way that makes sense, consistent with law, is the way that we're requesting it. Now, the second issue, if you don't want to get into the heavier issues, an alternative basis to reverse is to simply follow established precedent and conclude that the plaintiff did not prove all of the requisite elements to reestablish the lost note. The one that we appealed based on is that it did not establish the first element, which required the lender show it was entitled to enforce, or that it acquired ownership from a person entitled to enforce when the note was lost. Now, it clearly didn't show the entitled to enforce aspect. It was never the holder. It admitted it was never the holder. That's on page 32 of the trial transcript. The note was never endorsed to the bank or blank endorsed. So it clearly can't have prevailed on that aspect. So this aspect of the case hence turned on whether the bank proved that it acquired ownership from a person entitled to enforce when it was lost. Now, I think that the way this played out at trial is very telling. At trial, the bank's counsel asked the witness to testify about when it acquired ownership of the note. And initially, those objections were sustained on pages 21 through 23 of the trial transcript. And then the bank tried to ask again, elicited another objection, and then counsel moved on. That's on page 26, and said, well, let's get to the assignments of mortgage. And there were 4 assignments of mortgage that they used in order to try to establish ownership as required under the first element of the statute. The obvious problem is that the 4th assignment only conveyed all beneficial interest under the mortgage, not the note. And there's a long-standing line of cases from this court and all other DCAs, probably 15 cases that say this at this point, including Caballero and Gui. I guess Your Honor calls it GY. I changed my pronunciation of that after you said it at one of these oral arguments. So Caballero and GY make very clear in a binding precedent assignment of the note without an assignment of, an assignment of the mortgage without an assignment of the note doesn't accomplish anything. That's precisely what you have here. All beneficial interest may be a broad term, but it only applies to the mortgage itself, not the note. Now, a couple notes here about what the record reflects. The bank's witness at trial admitted she didn't know what that term meant. That's on page 93 of the transcript. And the bank's counsel actually objected when we asked what that meant, or trial counsel did, that called for a legal conclusion, and that was sustained. So clearly, we're traveling under a de novo standard review of what does the term all beneficial interest under the mortgage mean in this context. I think the line of cases that we've cited, Caballero and GY, are clearly controlling and on point. The bank tries to argue otherwise, but its arguments, I submit, are simply not well taken. They cite Johns versus Gillian first, but in that case, the Florida Supreme Court talks about a beneficial interest of the note. I wrote it down here. The quote was, beneficial interest in the securities. And that case simply stands for the proposition, if there's an intent to convey or assign the note, then the mortgage travels along with it. And it's clear in that case that case wasn't limited to an assignment of the mortgage, as you have here, but it was an assignment of the note, and the mortgage hence went along with it. So that case doesn't help their position. My opponent then tries to refer to the witness's testimony at trial as if that justifies affirming the final judgment. But I think there's several points here that I think are telling. First, my opponent doesn't even talk about, even though we briefed it in the initial brief, how that testimony wasn't admissible. It's very clear under this court's decision in Sass and many others that testimony about the content of documents which are not in evidence is not admissible. Here, there was absolutely no documentation showing an ownership interest at all. So the witness's testimony that the bank owned this note as of a certain point in time without any documentation was inadmissible hearsay. The trial judge initially sustained those objections and then changed course only once he allowed the assignments of mortgage to come in. That testimony should not have been admissible and did not justify the final judgment of foreclosure. I cite in the brief the 5th DCA cases which make clear that in this context, they actually go ahead and just hold that testimony of a witness is not sufficient to prove standing in a foreclosure case. There has to be documentary evidence. I think they've sort of built in the hearsay issue to that holding. But even if your honors don't want to go that far, it's pretty clear that there's simply no competent substantial evidence in this record to show that the bank was the owner of the note at any point in time. The witness's testimony in that regard was simply not sufficient, particularly where she acknowledged that she didn't know what the term all beneficial interest meant, and particularly where the bank was taking the position that that was all just legal conclusion up to the courts to decide. Now, the only other issue that my opponent argues on the issue of standing is, well, Chase was the servicer, and they try to say that, well, we wouldn't have been incurring these expenses if we didn't have standing. This court's decision in St. Clair makes very clear that a servicer's payment of expenses, taxes, that sort of thing, does not prove standing in a foreclosure case. It's very clear that the mere fact that Chase made expenditures doesn't prove that this plaintiff trust was the owner of the note at any point in time. There's no precedent that my opponent can cite to in that regard, and this court's decision in St. Clair forecloses that possibility. Also note that the limited power of attorney that they've tried to rely on for that position as well, not only postdated the filing of the suit, but wasn't even effective as of the time of trial. And that proposition this court dealt with in the Russell decision, where it explained how the limited power of attorney didn't accomplish anything in the plaintiff's prima facie case of standing, where it postdated the filing of the case and made no reference to the particular loan in question. So I submit that it's appropriate to reverse based on the statute of limitations issue. It's also appropriate to reverse based on the plaintiff's failure to prove that first element of its lost note claim. Either or both is an appropriate basis. I'm not arguing the third issue. I don't think we have a need to get into that given the case law that's emanated since that point. We're also asking for an involuntary dismissal as the remedy on demand, and on remand, excuse me. And in that regard, I note that my opponent has not even quibbled with that remedy at any point in the brief, so that would clearly be the appropriate result, is an involuntary dismissal on remand as opposed to a new trial or any other relief in the event that your honors reverse. So unless there are any questions, I would save the rest of my time for rebuttal. I thank you.
All right, you've got 5 minutes left for rebuttal, Mr. Stopa.
Thank you.
Good morning, Your Honors. Chris O'Brien on behalf of the appellee.
What was your name again?
Chris O'Brien.
Are you with Pearson Bittman?
I am, Your Honor.
All right, you may proceed.
I think first we should address, counsel stated there's a statute of limitations for everything. That is not quite right. As you pointed out, there's certainly none for murder, but there is a statute of limitation for causes of action, not an element of a cause of action. In this case, in the trial court, it was argued, and the citation was given to the Mason v. Rubin case. And that case stands for the proposition that a plaintiff seeking to reinforce a lost note, an instrument, a negotiable instrument, under 71011 fails because the statute, 71011, provides that this is how you reestablish documents unless otherwise provided. Well, a good example of when it is otherwise provided is 673-3091. And that's what the court in Mason v. Rubin found. They found that you have to move under 673-3091, which is, in fact, more stringent than the requirements under 71011 alone. Now, one of the things that I think is most interesting between the two statutes is 71.011 requires, and let me read it here, any person desiring to establish any paper, record, or file, except as otherwise provided, shall file a complaint for that purpose, clearly indicating this is a cause of action in and of itself. 673-3091 contains no such language. In fact, the language in 673-3091 supports the position that the trust took in the lower court action. 3091 is entitled Enforcement of a Lost, Destroyed, or Stolen Instrument. Enforcement. A person not entitled or not in possession of an instrument is entitled to enforce the instrument if, and it goes on to state what is required to enforce. In the briefs, the trust defines enforce, and I think it's important to recognize that the legislature chose to use that language as opposed to reestablish. Enforce, as defined by Black's Law Dictionary, is to give force or effect to compel obedience to, or to compel a person to pay damages for not complying with a contract.
So it seems to me what your position has to be, correct me if I'm wrong, is that if you're trying to enforce a lost negotiable instrument, that it really shouldn't be looked at as a separate cause of action. It's just part of the action to recover on the note or enforce the mortgage or whatever. In other words, it's ancillary to the suit on the note or the suit to foreclose the mortgage.
Yes, Your Honor.
And that we would, the fact that we have separate counts for mortgage foreclosure and enforcement of the lost note is really just kind of administrative convenience type thing, and they're not really separate at all. They're all rolled up together.
It is, Your Honor, and I think the drafting of complaints, foreclosure plaintiffs may not be all that ingenious or ahead of the curve in adopting proper drafting techniques, but that doesn't change the fact that it is not a separate cause of action under the statute.
It makes it more convenient procedurally because in the past, at least, it was my understanding that the banks or the bank's counsel always included a lost note count with their mortgage foreclosure because the procedures were such that they never knew if they were going to get the note or not. So they did that, and then they could dismiss the lost note lost note count if they in fact received the lost note. It's different now, but
Certainly,
that's the
Your
way
Honor.
things used to be.
Yes. And to further that point, I think to indicate that it is, in fact, a part of the cause of action, and I think you said incidental, is that it is one of the subsections of 3011. It is the third subsection of who is entitled to enforce. And so what counsel is asking the court here today is to create a statute of limitations for a party to prove its own standing. I think standing in mortgage foreclosure, it's become, this court has noted, it's become axiomatic that plaintiff must have standing at the filing at the inception of the action. But I think we've come far enough that I don't think it's necessary to create a statute of limitations for a party to show its standing. That is part of the action itself. It is under 3011. It is now part of plaintiff's prima facie case for foreclosure, but it is not a separate cause of action unto itself. Simply because, like I pointed out, the language for reestablishment requires you file a complaint. 3091 does not require that. It is simply part of your standing under 3011. So I think that argument simply has to be rejected, and I think part of the reason, and there is no case law on this, as counsel has stated, I've searched far and wide. There's nothing, as far as I can find, in any federal district court, in any state court, in all of Florida, nowhere. And I think part of that is because of it's a common sense approach. It is part of the foreclosure. Should a plaintiff seek to reestablish the note under 71011, it would be rejected under the authority of Mason v. Rubin. So I think the statute of limitations is not well taken. And in fact, if there is an argument to be made that a plaintiff waits too long to enforce the lost note, they can raise the equitable defense of laches. Now, of course, they'll be forced to show some disadvantage or prejudice for that, but there is still a remedy should the court find, or should defense find or feel that it was unduly delayed in bringing the action. Moving on to the standing argument, I think, and there is a lot of case law in Florida about the effect of an assignment of mortgage only. Much of the case law that is cited by the appellant in the brief references an assignment of mortgage that does not assign the note creates no rights in the assignee. We don't have the language of many of those assignments.
This is pretty common language in my experience, though, right? I mean, doesn't this all beneficial interest language appear in an awful lot of these things?
In many, there's many that just say assignment of mortgage, the mortgage is assigned with no other language. There's many different forms. I wouldn't say it's rare, but I would say many of the assignments that only assign the mortgage literally only say the mortgage is assigned.
Can you address Mr. Stopa's argument about the Johns case? Because frankly, that was the thought I had too. The object of the all beneficial interest language is the mortgage. And while the mortgage follows the note, it's not the other way around.
No, it is not the other way around.
So why would an interpretation of that all beneficial interest language require that when the object of that language is the mortgage that we bring in the note?
Well, so I think the point is the intention of the parties, and which is what the court is supposed to do. The intention of the parties controls. And the language in Johns is interesting in the sense that it refers to a beneficial interest in the securities, not a singular security. It means both. Now, I think it's fairly common practice that, and it's to our detriment in the legal field, that when financial institutions refer to the mortgage, they mean both documents. But I think the saving grace of the assignment of mortgage, the fourth assignment of mortgage, and that's another thing, is that here we have a complete chain.
Circumstances, for instance, and I'm sorry if I'm getting too far afield just into industry practice, but where that default setting is not true, for instance, where the holder or owner of the note might assign the mortgage to a servicer for purposes of enforcing it,
For another reason.
but retain the note and grant the servicer the right to enforce it in some other way.
Certainly, and I think if there's an indication to that, that should certainly control. However, in this instance, the note has already been lost. So I don't think that that's the situation here. And more importantly, when we look at the fourth assignment of mortgage, the bank signs, and let me take a look at the language here.
You're not suggesting that because the note's been lost, then you can't transfer the
No.
note?
No, I am not. My point in that was simply that there is no clear indication that the note was intended to be severed. And let's explore the language of the fourth AOM, an assignment of mortgage. So, for value received, the undersigned assignor, and it recites the parties, does hereby grant, bargain, sell, assign, transfer, and convey all of assignor's right, title, and interest. All right, so all of its right, title, and interest. Let's take a look at what that right, title, and interest is. And we can find that by going to the third assignment of mortgage, where EMC received its rights from Manufacturers and Traders Trust Company. And in that, Manufacturers, Traders, and Trust Company transfers, grants, bargains, sells, assigns, transfers, and sends over to EMC Mortgage all of its right, title, interest as holder thereof, and in and to the following described lien, described the mortgage, together with the note or obligation described in said mortgage, goes on, same unto assignee and to the successor's legal representatives, and assigns to the assignee forever, an assigner hereby constitute and appoint said assignee, its attorney irrevocable, to collect and receive said debt, and to foreclose and enforce. So, what interest is being transferred to the plaintiff trust by EMC in that fourth? Well, all of the signer's right, title, and interest. What is that interest? The note, the right to foreclose, the right to collect payments, all of that. It goes on to say...
It sure seems like if the intent was to, to assign all of that to the Bank of New York Mellon, it would have been awfully easy to add similar language to the fourth assignment of mortgage, and it just is not there.
Well, they certainly could have, and it would make my job a lot easier had they just said no. There is no doubt to that. However, I don't think that there has to be a recitation of a magic word. I think that there can be an intent shown by other language. And clearly, in this case, I think that is done.
But the object of that language in the fourth assignment is the term mortgage. That's like, I would agree that we might engage in this kind of effort to ascertain an intent more broadly, where there's some ambiguity in the operation of the language. But I just, it's just weird. It's all beneficial interest in a document, right? And the document's the mortgage.
So, under the beneficial interest, yes. However, the first part is all of the signer's right, title, and interest. Then, all beneficial interest under a certain mortgage. So I think it assigns all of its interest, then a beneficial interest under the mortgage. And there's been no alternate explanation as to what a beneficial interest is in any event. The lower court found, through the evidence and testimony that was presented to it, that the beneficial interest is in fact the right to have a sufficient stake in the documents to enforce them. I don't think that because it does not say the word note, it is completely null and ineffective. If it just says mortgage, if it only says this is an assignment of mortgage, I think there is a fair point to be made that that is a clear indication that the parties intend to separate the note and the mortgage. I think when you have language that refers to all of its right, title, and interest, and that right, title, and interest includes the note, includes the right to enforce, that they are clearly assigning that as well. And, you know, we discussed the language in Johns v. Gilliam and the intention or the beneficial interest language. The purpose of Johns v. Gilliam is that it is the intent of the parties. In fact, in that case, the assignment was null because it was not executed properly. However, it was still given legal effect because it is the intention of the parties which controls. And I think, you know, with no alternate explanation provided and the language of all of a signer's right, title, and interest, I think there is clearly a showing that they intended all of its right to go. Now, certainly, they could have added note, and we'd be in a lot better position had they done that. But I don't think that makes it void. There's a long-standing legal principle that's best summarized by the Latin phrase, ut res magis valeat quam pereat. And that means it is better for a thing to have effect than to be made void. And when a document can be given legal effect and it can carry out the intention of the parties, it should be done so. It should not be made void simply because it is missing a magic word.
No one's saying it's void, it's just, it looks like it transfers the mortgage and not the note.
Well, and I guess void per se, but what right in Florida does a mortgagee have to enforce the document? And the case law is clear on that it's none. So to assume these parties would go through the effort of drafting this document, paying for the drafting of this document, executing the document, recording the document, when it states all of a signer's right, title, and interest, to assume they're doing that simply to make a record of assigning the mortgage and no other right, I don't think is a fair interpretation, in that it is strictly construing the language of the agreement against the parties to the agreement solely for the benefit of the defaulting borrower. To construe that strictly is there's no other explanation
The other side of that coin is that if they wanted to include the note in the assignment, it would have sure been awfully easy to do that. It wouldn't have taken more than the addition of 3 or 4 words.
Well, so I guess the best analogy that I can give is if you have a quitclaim deed and you assign or you deed all of your right to the property. You don't detail. Certainly you could go in and say, well, it's the house over there at 123 Main Street and the house at 124 Main Street. But by assigning or by deeding all of your title, it is everything you have. Which, if you own 123 and 124, it includes both of those. Now, that often leads to problems in the interpretation of deeds, where it is unclear. However, they are to be given legal effect. And if it is all of your interest, that is what you have bestowed. I think, finally, the one important thing I think to point out is that in this case, there was a substantial amount of evidence presented. There's a complete chain from originator to the plaintiff. It's not a situation where there's a blank endorsement that pops up years and years later, and there's no way to track who had what when.
Mr. O'Brien, you're at your 20 minutes, so you need to wrap up at this point.
Finally, the last thing I'll say is that a trial court's finding at a bench trial are clothed with the presumption of correctness if it's based on substantial and competent evidence. Here, the court found that the assignment did bestow standing, and I think it is not the role, or it is the role of the appellate court to indulge every fact and inference in support of the trial court's judgment. And here, I think there is competent, substantial evidence with the assignment, with the witness's testimony, to show that the plaintiff did indeed have standing.
All right.
Thank you.
Thank you, sir. Mr. Stopa, you've got 5 minutes left for rebuttal.
Thank you, Your Honor. Most of what I argued, my opponent had no opposing argument for and no opposing case law. I think that's very telling. On the issue of the statute of limitations, my opponent really confined his argument to the suggestion that a claim to reestablish a lost note is part and parcel of a foreclosure claim as opposed to a separate cause of action. There's no legal authority presented in support of that proposition at all. That proposition is contrary to their own complaint. Their own complaint sets forth 2 different counts. Count 1 for foreclosure, count 2 to reestablish a lost note. Every foreclosure complaint that seeks to reestablish a lost note that I have ever seen is set up in that same way, with them as 2 separate causes of action. There's clearly a reason for that. This court's decision in Correa was the first decision that talked about the lost note elements in a foreclosure case. That treated the element, a lost note claim, as a cause of action. Every decision since then has treated it as a cause of action. Florida Rule of Civil Procedure 1.115 views it as a cause of action. Florida Statute 702.015 views it as a cause of action. Everywhere you look, this is viewed as a claim, not as an element of a foreclosure claim. So this is clearly a separate cause of action. I think another way to look at that is, would it be possible for a foreclosing lender to plead and prove a lost note claim separate and apart from a default? The answer to that is clearly yes. It would clearly be possible, because you don't have to be in default to reestablish a lost note. They are clearly separate claims, separate causes of action. And just because as a pragmatic matter, most of the time, lost note claims are brought as part of a foreclosure, it doesn't mean that they're not separate causes of action. They clearly are. When you think about the elements of a lost note claim, that can be brought even if someone's not in default. So they exist separately. It's clearly a separate claim, clearly a separate cause of action. And our case law, the Florida legislature and Florida Supreme Court all treat it as a cause of action as opposed to part and parcel of a claim. So I submit that a reversal on that basis is appropriate, and that will give some guidance to courts in the limited circumstances when this fact pattern arises. I also think that it's appropriate to reverse on the second issue. My opponent talked a lot about the intention of the parties, but there was no parole evidence of the intention of the parties. The intention of the parties is memorialized by the 4th assignment of mortgage, and I think it's very telling that my opponent stopped reading when it stopped reading right after all of EMC's right, title, and interest. Stopped reading. Because it's very clear, the way Your Honor's been phrasing it, that the object of that phrase is under a certain mortgage.
And Mr. Stopa, what exactly does that convey? Let's say EMC did intend to convey all of its right, title, and beneficial interest under the mortgage. What does that mean it is conveying to Bank of New York Mellon?
Well-
What does Bank of New York get out of that?
Under this court's precedent in Caballero and GY, that conveys nothing. So it doesn't get anything out of it. Now, I submit as a pragmatic matter, what that does is it alerts those in the official records that any quiet title lawsuit couldn't be prosecuted without that. So does it actually convey the note under this court's precedent and all the other DCAs? No. Now, it does alert third parties, so it's not a nothing in the sense that it serves a purpose for public records purposes. But other than that, it doesn't do anything under existing case law. And what my opponent asks you to do is he just asks you to ignore that entire line of cases without any reason and without any case law supporting it. There's no basis for you to contravene this court's established precedent in Caballero and GY. And my opponent doesn't give you any. Doesn't give you an opposing case. The only case he really cites is the Johns case, but it's very clear that in that case, the beneficial interest that was assigned was all beneficial interest under the note. It's very clear. And I don't necessarily disagree with the general proposition that the intention of the parties is what controls. I also don't disagree that it's possible that the intention of the parties could be used to establish that there was an intent to convey the note as well, even if the magic word note wasn't in the assignment. But you don't have any such proof here. There was nothing. The witness had nothing, and the only document just doesn't show it under this court's precedent. So it's very clear that the requisite standing to reestablish the lost note under that first element was lacking. This bank was never the owner. As Judge Wallace indicated, it would have been very easy. And I do these cases by the many hundreds. I've seen many hundreds of assignments that actually include the note. I'd say most of them do. Occasionally, there are assignments that don't. Why did this lender choose to do it like that? Why did EMC, the third party involved on the third assignment, choose not to include the note? We don't know. The record is silent.
You've exceeded your time. You need to wrap up now.
But where the record doesn't reflect that, that was their burden of proof and is another basis for reversal. So for either or both reasons, this court should reverse. Thank you.
All right. Thank you both. All right, our next